We're ready to go on the record now. We'll call the case of People versus Michael Marvin first. This is filed for 45339. Mr. Sherman, if your client can come up to the podium there, please. If I can have counsel, please, your appearances on.
You're a cook on behalf of the people.
James Sherman for Michael Marvin.
I'm set for sentencing this matter. The record should reflect Mr. Marvin is present here in the courtroom today. Mr. Marvin, have you had an opportunity to go through the pre-sentence report? Yes. Mr. Sherman, about that? Yes. Okay. Mr. Sherman, are there any additions or deletions or corrections that report?
No, Your Honor.
Are there any challenges to this guidelines?
No, Your Honor.
Ms. Coe, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this warrant?
No, Your Honor.
Anything on behalf of the people for Alex?
The court sat over the jury trial, is familiar with the facts. Mr. Marvin, has some issues. He has done, I probably should have revoked his bond months ago, to be honest with you. He has continued to miss tests even after the PSI. I got a message yesterday that he had missed 3 more tests. He hasn't done great on bond. I think the recommendation is appropriate. His guidelines are high, but they're high because of, his history and because of the charges. And because he has the concurrent charges. I asked the court to follow the recommendation. Thank you.
Thank you, Mr. Sherman. Anything on behalf of your client today?
Yes, thank you, Your Honor. As you know, Mr. Marvin's here today for his sentencing after he was found guilty by jury trial on 3 felony counts, 2 resisting and obstructing a police officer and 1 operating while intoxicated. His 3rd offense. I would advocate this court, I would request this court depart from the recommendations of the department to the extent that they recommend any term of incarceration. While the charges here that Mr. Marvin was found guilty on are severe, they do stem deeply from a context of alcoholism. Clearly has a problem, as the people just pointed out. I don't think it reflects a pattern of violent or criminal behavior, more so a crisis and substance abuse issue that needs to be treated. While alcoholism did contribute to the actions Mr. Marvin took that led to these charges, he has a motivation to seek rehabilitation even months before now, or at least a month before now. Mr. Marvin and I have went back and forth looking for potential AA classes, counseling sessions, other rehabilitation services through Northwest Michigan Community Health Center, which actually waitlisted Mr. Marvin for reasons he can expound upon. But he does have a motivation to change in the future. He's remorseful for what he's done. You were here for the jury trial and were able to observe Mr. Marvin's demeanor, even the things he said during the trial. He was respectful and polite, even before the trial, during his pre-trial appearances. He has had some issues on bond, but as the state pointed out, only regarding testing for substances. Mr. Marvin's a 44-year-old veteran. He's overcome substantial obstacles, including obtaining his GED and solely supporting his family, his wife who's here today. And despite his past criminal history, his current circumstances, I believe, present an opportunity for reformation. And support from his family and friends and the stability of his living situation, I think, further bolsters a probationary sentence over any term of incarceration. As the state pointed out, Mr. Marvin does have pending criminal charges in Maryland, but I would point out that those criminal charges are pending from 2004. I'm not sure what they're doing with those, but it surely doesn't look good for Mr. Marvin, but it does bolster his argument for a probationary sentence over any term of incarceration, especially a 12-month term. because he will surely have to resolve that matter in Maryland and appear soon. And he plans to do that. So I think it will be a lot easier for him to appear and resolve his matter in Maryland if he's not incarcerated, of course. As I pointed out, the department recommended a 3-year probationary sentence, but page 2, condition 15, number 15 of the recommendation recommends the first 12 months to be served in the Crawford County Jail. Again, I asked the court to depart from that recommendation to the extent only as to number 15 on page 2. 4 factors that I know the court must consider when sentencing Mr. Marvin, such as protection of society. I believe strict compliance with terms of probation will protect this society in the same way as if Mr. Marvin was locked up. It's better for him to have a probationary sentence so that he can rehabilitate himself, reduce the risk of future offenses, which would ultimately protect society in the long run, not just for 12 months. Obviously, Mr. Marvin must be punished. As this court knows, the punishment must be proportionate to the crime committed. And given Mr. Marvin's efforts thus far, his current circumstances, a probationary sentence would be just and fair, giving him an opportunity to acknowledge what he did wrong and at the same time working towards positive future behavior. Lastly, and probably most important, deterrence from doing this again. It's just one factor to consider, but a probationary sentence would accomplish deterrence for Mr. Marvin. Engaging in the acts that led to these current convictions, reinforcing the seriousness of the acts that he did, and giving Mr. Marvin an opportunity to address his mistakes, rather than having the opposite effect, which I feel incarceration will do, further entrenching him in a cycle of criminal behavior. We don't want to see, Mr. Marvin does not want to be here again. I know I don't want to see Mr. Marvin here again, and nor does this court. So in conclusion, I respectfully request this court to impose a sentence of 3 years probation for Mr. Marvin with no term of incarceration. I believe this approach not only aligns with rehabilitation and the goals of this court for that, but protects the community and acknowledges, it allows Mr. Marvin to acknowledge what he did wrong and work towards a better future. I guess lastly, I'll just note on a kind of like a side matter that I thought it was odd that there was a term of incarceration as a condition for probationary sentence, because probation inherently is something other than incarceration. I think Mr. Marvin has shown through compliance, substantial compliance with his bond conditions, that he can do the same during a probationary sentence, complying with conditions without the need for incarceration at all, which is what a probation contemplates, that Mr. Marvin can prove he can be out in society, follow the rules without being basically being a productive member of society, as he is now. Not only that, but he, as I pointed out, is the sole provider for his family. Mortgage, other expenses that are solely paid by Mr. Marvin, and his VA and SSDI benefits that he stands to lose if he is sentenced to anything. I do think the first 12 months, whatever sentence Mr. Marvin has, would be the most important. I don't think that should be spent behind bars. Rather, he should be working towards the services he's already attempted to participate in. I have supporting documents here that Mr. Mertz provided me to show some of those efforts, as well as 2 support letters from his wife and his stepmother, Grace. If I could approach it. provide the court those to consider.
Yeah, Ms. Cook, have you seen those?
Yeah.
Ms. Cook, take a look at those.
Yeah, bro.
Yes. Okay, I had a chance to review those documents. Did you want those attached? Yes,
Yes, right.
Mr. Marvin, anything that you wanted to say to that?
I've been an alcoholic for 20-something years. And by that, I don't mean that I've drank every minute of that. I have periods of time, 7, 10 years, 13 years the first time, where I'm fine and I think I'm doing good, and then I get pulled down by something. And me and my wife have decided that I just don't need to drive, because I do good for 7, 10 years and then I have a bad moment and that's it. It's just not worth it to me anymore. I could have dealt with everything way better than I did. I got myself paranoid, frustrated, and I didn't know how to deal with it. And I only had to wait a half an hour for my wife to get home instead of making the decisions I did, and they were wrong. I don't believe, sir, that when I said that I had a panic attack, I don't believe that I wasn't saying that the police caused that, sir. I have them daily. It's part of my life. And when I'm doing something that is stressful, that is when it is most likely going to appear. And I just want to reiterate, because I said that before to the prosecutor, that I didn't believe that that those police officers were bad in any way, or that they did anything wrong to cause it. It's my problem. I don't blame that on them. I understand that, sir. I just wish that I would have dealt with things better. First time, the first incident in July, as soon as that happened, sir, me and my wife got right on the phone and tried to get me into the VA here. It has taken us until literally yesterday to get in. I got my blood work done yesterday and I have an appointment on the 14th. That is where I have found my help when I said that I've been an alcoholic for 20 something years due to the reasoning behind the disability, sir. I didn't talk about it for 18 years. I didn't even try to get help until 6 years ago. And I got into the VA, and that was by accident. I was sent by the court to see a counselor. And she told me, she said, you know, I don't think I think you need to deal with the underlying issues. And she helped me get a hold of the VA, where I switched a lot of medications up. I'm now on one medication. I was on 7, including Xanax, sleeping medications, everything that was given by a civilian doctor. When I got with the VA, they got me on the right track. I do think that I need another evaluation for medication. My wife has taken over distribution of my medication, because when I get depressed like that, I miss days, not intentionally. But at the end of the week, I'll see that I missed 2 or 3 days. So she's taking over that. We have I messed up. You know, that's all there is to it. I let myself get in my own head. My wife calls it a rabbit hole. You know, I get fixated on things and I get paranoid, and I can't get them out of my head, and I can't let them go. And I'm not usually like that, and I'm strong, I'm intelligent, and that's what pisses me off. Excuse my language. Say, I do so good for so long, and I just think that I'm okay, and I'm not. And with this was my fault. When we moved, I was doing really good, and instead of moving the VA from Traverse to here, I didn't, because I was in a good spot, and I didn't realize until, like I said, a year ago, that I needed it. And at that time, you know, it was too late. Unfortunately, I got in trouble before I got in, but that is what I believe that I need, is the counseling that I get there is specialized for my type of PTSD. I believe that I need an additional medication, or a uppage of medication. I've been on it for 6 years. It's a very light medication to begin with. And I just don't believe that it's having the same effect anymore. I'm very bouncy, as you can see. I don't have any more to say, sir. I would like to say that, you know, I got a service dog and a service dog in training, and I love my animals, and I love my wife, and that's all I have. You know, when she met me, she pulled me out of a lot of bad things. And I know that looking at me right now, I'm not in the best place, but I'm telling you, I've been a hell of a lot worse. I fought to get here, to get us a house and to start over. And I tried, sir. And I believe that the fact that I was detoxing, you know, when this happened, sir, shows that on my own initiative, I wanted this. And you know, that was something that I was working on, and I wish that I would have been able to finish it before that day, but I wasn't, sir, and I made mistakes. That's all I have to say.
All right, thank you. I read through the pre-sentence report. That gives me a lot of information about you and your background based on what's in that report.
Yes.
Obviously, I presided over the trial. I heard all the evidence against you. And so I'm fully aware of all the facts in this case. And then, of course, there's more information in the pre-sentence report about the issues that you had while you were on bond, as well as your outstanding issues in Maryland. So, there's a couple things I guess I would point out that stood out to me as I looked at all the facts of this case. Number one, based on the report, you have 31 positive PETs, 36 missed PETs while you were on bond, and that's just as of the time of the writing of the report. This code indicates there's been more since then. So, to the extent you're saying that you have control of your problem, or you're trying to get control of it, that doesn't show to me at all that you're trying. It shows to me you're just continuing to do what you've been doing. The fact that you're, the documentation about seeking out help, maybe you've taken the first step to seek out help, but you haven't gotten any help yet. You haven't been going to any AA meetings. I don't think there's any reason why you couldn't have been doing that during the pendency of the case. Typically at sentencing, people bring me sheets of their AA attendance that they've been doing. So you haven't been doing that. So, the claim that you're trying to get a hold of this, or you do have a hold of it, to me is just completely untrue and meritless, which kind of fits in with your entire position throughout this case and your testimony at trial, which was clearly untrue. You told to tell the truth, you sat here and told a story that wasn't supported by any of the evidence and was completely unbelievable to me and to the jury, obviously. So I think you're just you're fooling yourself, first of all, and I think you're trying to fool everybody else, but none of the things that you're saying are backed up by any real action. You've got some charges in Maryland that have been outstanding for 20 years. Yet that somehow now, by being on probation, somehow go back to Maryland and now answer for those charges. If you were going to answer for those charges, you had 20 years to do it. And I suspect if you were ever to go back to Maryland, they would arrest you. If you were there, you would have to answer for them. That's why I suspect you haven't been back there. So, all of those things are factors which, in my view, do nothing to mitigate your case or convince me that any lesser sentence should be imposed at all. And that's to say nothing of your actual actions in this case, which was to drive drunk to the sheriff's department and then confront employees at the sheriff's department while you're under the influence. You put yourself at danger, you put everybody else in danger coming to the sheriff's department that day. And so for all those reasons, I mean, I think a prison sentence could have been argued for here, wasn't argued for. And I do think the recommendation is appropriate given all of the circumstances. And so I am going to follow that recommendation. We're going to be on probation for 3 years, which is a lengthy period of time. And I'm going to tell you right now, based on what you did on bond, I'm not holding out a lot of hope that you're going to comply with probation. And if you don't, what you need to understand is the next step is prison. So if you are going to get things in line, now is the time to do it. And I understand that you've got some underlying conditions, and I think those are valid, just based on what I saw at trial and what I've seen. I have no doubt that you have legitimate underlying conditions that need some treatment. But none of those conditions excuse the lying, excuse not complying with bond. You can do all of that with those conditions that you have.
May I speak up?
So none of those are an excuse for that.
May I speak on the list?
You've had an opportunity to talk.
Yes, sir.
I didn't stop you. I wanted to say everything you wanted to say. Now it's my turn. So I do think you have some underlying conditions, but you aren't doing anything really to treat those and to help those. Really, you might think that you are, but based on your behavior and circumstances, to everybody else looking at this from the outside. So the court is going to place you on probation for a period of 3 years. The court is going to adopt all the terms and conditions listed in this report as the terms and conditions of your probation. The court is going to order that you serve 12 months in Crawford County Jail. You do have credit for 20 days served. The court is going to order restitution in the amount of $125.01 for OEYL testing reimbursement pursuant to statute. Crime victims assessment of $130, court costs of $325, $204 state cost. And then while you're on probation, a supervision fee of $30 per month. You do have the ability to seek an appeal of this sentence, and Mr. Sherman, on the table there, there should be papers. Have Mr. Marvin acknowledge that he's received. And for the record, all those sentences to be served concurrently.
Your Honor, Mr. Marvin's had a chance to review this.
He gets one of those copies for his records, and then he just leave the rest on the table. He needs to, there's a spot on there for him to initial and acknowledge receipt.
Oh, yeah. No.
Yeah, and then move to the officer.
Thank you, Your Honor.
People versus Joel Wilson, file number 255421.
Anthony Juliet on behalf of Mr.
Wilson.
Thank you. This is set for a status conference in this file today. Mr. Stevens, from status.
Your Honor, this is our first appearance in circuit court, and unfortunately, there are some new developments for which is unrelated to this file. Be that as it may, Your Honor, I would ask the court to consider giving us a somewhat of an extended period of time. There's another file that's now in district court that's not been bound over, whether it will or won't be, I guess I don't really know. Additionally, Your Honor, he's going to have to make a determination of whether or not he's able to retain someone or an alternative that he's going to ask for, or if he qualifies for appointed counsel. So if the court gave us a period of time, I'm not sure what that specifically means. And I know it's more difficult for Mr. Juliet because he's coming from a place that's not here. But if you gave us 60 days, that probably hopefully would be enough time for the other file to somewhat catch up in order for either myself or a different attorney or both attorneys to be able to try and work something out relative to all the files. Additionally, Your Honor, to the extent that it's bound over, which clearly it's not been bound over yet, but if it were bound over, I'm not sure if it could be assigned to you so that all the files could be with you.
Are you the counsel on the other?
I'm not, Your Honor, and I'm not sure that he can afford to retain an attorney in that one. I'm not sure if he qualifies for an attorney
Has he been arraigned on those yet?
Yes, Your Honor. And so my understanding is that he has preliminary examination somewhere in August.
Okay. All right, Mr. Juliet, would people take any position on the request for adjournment?
No objection. The preliminary exam is on August 19th. Mr. Thompson was assigned yesterday. So I think maybe letting that file catch up, to catch up to this file makes sense.
Okay, so I guess, Mr. Juliet, I'm just gonna make a request that, if that is bound over, you can notify Mr. Thompson and this report, request to have that one assigned to me, so that both cases are in my court. That would make sense from an administrative standpoint. And then, I will set this for a status conference in 60 days. If that case is bound over, then the court will set that for status conference at the same time. Juliet, anything else to address for you today?
No, thank you, Your Honor.
No, Your Honor.
Mr. Wilson, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay, so just make sure that you stay in touch with Mr. Seeger, and if you have another attorney in that other case, make sure to stay in touch with them as well, okay?
Yes, Your Honor.
All right, thank you.
Thank you.
Thank you, Your Honor.
People versus Bancroft, case number 255420.
Here, on behalf of the people.
James Dick on behalf of Mr. Bancroft, who's standing to my right, Your Honor.
Thank you. This is the date and time set for a status conference in this case. The status of this file for the defense.
We have a resolution, Your Honor. I have a signed advice of rights form and the plea sheet for Mr. Bancroft.
Okay.
May I approach?
The offer and the plea are resist and obstruct and domestic violence. All the additional charges and the enhancement will be dismissed.
Okay. All right, Mr. Bancroft, have you had an adequate opportunity to discuss this plea agreement with your attorney?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bancroft, at the time that this incident occurred, were you on probation or parole?
No.
And you understand that by pleading guilty to count one, which is resisting or obstructing a police officer, that's a felony that carries with it a maximum possible penalty of up to 2 years and under a $2,000 fine. You understand that?
Yes, sir.
And that domestic violence as a second offense is a misdemeanor that carries with it a maximum possible penalty of up to 1 year and or a $1,000 fine. You understand?
Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges?
Your Honor, may I clarify? The domestic violence, it was reduced. The enhancement was being dismissed.
Oh, I see. Okay, sorry. Just to confirm that.
That's correct.
All right, so Mr. Mr. Bancroft, that domestic violence charge is a first charge, which means that the maximum penalty you face would be up to 93 days. Yes. With those penalties in mind, what is your plea to each of those charges today?
No contest.
Yes.
If that's acceptable. And the basis is alcohol consumption, Your Honor.
Your Honor, I
But
wasn't
if-
aware of that, but I don't have the police report available. If the court has it, I don't have an objection to it. It does show the elements pretty clearly.
I can provide that on my laptop if the court would be willing to review it there.
I don't need to be part of the file.
All right, so Ms. Koch, you don't have an objection to a no contest plea?
I do not.
The court finds based on the information with the police, within the police report and the representation of counsel that Mr. Bancroft was intoxicated during this incident. The court will accept that as a basis for no contest plea. Mr. Bancroft, I'm going to go through your rights with you. And, make sure that you understand your rights and what you're going to be giving up by virtue of this plea. So you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, not have that silence used against you. Right to testify at a trial yourself if you want it. You understand all those rights? Yes, sir. And by pleading no contest, you're going to be giving up and waiving all of those rights. Yes, sir. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave. That means you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end. Then you appeal. You understand that? Yes, sir. Does anyone threaten you with anything to plead no contest? No, sir. Has anyone promised you anything other than what we've said here in court today? No, sir. Is it your own free choice to enter this plea? Yes. The court is going to refer to State Police Report number 7276325, dated April 19th of 2025. Ms. Koch, have you reviewed that report?
I have.
And I'm looking specifically at pages 2, 3, and 4 of 7. Would you agree that the information contained on those pages would form a factual basis for a finding of guilt as to both the resisting, obstructing, and domestic violence charge?
Yes, Your Honor.
Mr. Dick, have you reviewed those portions of that report as well?
Yes, Your Honor, and likewise.
You would.
Yes.
Okay. So the court's going to mark and mark and admit that police report as Court Exhibit 1 that has the factual basis in this case. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Dick, are you?
No, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule and taking this no contest plea?
Yes, Your Honor.
Mr. Jeff, are you?
Yes, Your Honor.
Your Honor, there is a no contact provision we'd like to discuss with the court once we have finished the plea process.
Mr. Bancroft, the court finds that your plea is knowing and voluntary. The court is satisfied based on the information within Court Exhibit 1 that there is a sufficient factual basis to support a finding that you are guilty of each of these charges. The court will accept your no contest plea. This matter will be set for a sentencing hearing. You'll be notified of the date and time of that hearing. Someone from the probation department is going to meet with you today to set up a pre-sentence interview. It's important that you cooperate with that process and that you stay in touch with your attorney. So they're prepared to go forward. Makes sense. Okay. Yes, sir. Ms. Koch, in terms of the bond condition.
Your Honor, it's my understanding that there's an open CPS case. The child has been removed and placed with paternal grandparents. She's 14. I think she's almost 15 at this point. Defense counsel asked if I objected to the removal of the no contact provision in the criminal case. I don't, only because there's an NA case that, or a CPS case that can dictate that. So I'd rather have them deal with that. They are obviously more intimately involved with how Mr. Bancroft is doing in his process of reunification. I would just say to Mr. Bancroft that I hope that any such contact, if allowed by the court, would not be under the influence of alcohol, which is certainly Mr. Bancroft's issue.
And I'm assuming not using alcohol as part of the bond condition.
It is.
That isn't going to change. Is that right? Yeah. Okay. All right. So I guess, Mr. Dick, if you can get with Ms. Koch, prepare a stipulation to amend bond because there's no objection. Signing that.
Thank you.
Ms. Koch, anything further on this file today?
No, thank you.
Mr. Deck?
No, Your Honor.
Thank you. That's all for today.
Thanks.
Thank you.
People versus Jane Bartow, case number 255424.
Sierra Coke on behalf of the people.
Gene Staker on behalf of Mr. Bartow, who is standing to my right, Your Honor.
Okay. Can you tell me the status of this file?
Yes, we also have a resolution, Your Honor, but if the court would take an oral plea, I do not have the plea sheet. I have the signed advice of rights form now. In this, there is a resolution worked out to where Mr. Bartow would be pleading guilty to an added count of use of methamphetamine, and with the agreement that he could be sentenced to 7411 as a first offender in exchange for dismissal of the original offense.
Your Honor, that is a correct statement of the plea offer, almost. The PAT code is 333.74042A-A. In terms of 7411, I indicated I would not object to it as long as he was eligible, but that it would not be part of the plea agreement. So if he was not eligible, he could not withdraw his plea. He has some Ohio criminal history. They look like driving offenses. He looks like he's eligible to me. But sometimes they have things I don't know about. He would know that, not me, but I don't object to 7411.
Okay. So is this a 1-year use?
It is.
So, Mr. Bartow, first of all, you can.
Yeah, sorry.
Mr. Bartow. Is this the plea agreement that you discussed with your attorney? What we said you're enforcing on this, okay.
As long as it's this goes with the 74.
Yeah, so,
Sorry.
yeah, I'm gonna explain that a little bit further, and if you can talk to Mr. Dick, we'll go forward, but, just so that you're clear, the prosecutor's not objecting to 7411. I typically don't. For the most part. Because I think it's really no harm to the community and there can be a lot of benefit. But there may be some issues complicating that here, and you may not be eligible for it, which means that even if none of us object to it, the statute says you can't. And I want you to understand that if that's the case, you're not going to be able to change what we're doing here today. So what we're doing here today is going to be set in stone. Even if you're not eligible for 7411, you're still going to have to go forward as you plead today.
Can I transfer? So the only thing that would prevent me from that is a prior.
Yeah.
Then.
Drug conviction.
Everything's okay. Yeah, I have no prior or anything like that.
So okay, so do you understand all of what I said? Do you need more time to talk to Mr. Dick?
I don't think so. I'm done very well.
Okay. And does that change your mind at all about how you want to proceed?
No, you're not.
So can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bartow, are you currently on any kind of probation or parole? Are you on any probation or parole? And do you understand that by pleading guilty to use of methamphetamine, that the maximum possible penalty you face, you have to 1 year in jail? With that in mind, what is your plea to that charge? Now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. The right to testify yourself at a trial if you want it. You understand all of those rights. Understand that you're giving up and waiving all of those rights today. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you have to ask for the court of appeal to hear your case. You should say no and then appeal. Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court? pleading guilty because you are actually guilty of this charge. Information I have indicates this happened on April 15th of 2025. Is that the correct date?
Yes, Your Honor.
On that day, were you here in Crawford County?
Briefly, but it was, I'm new to the area, so a 4-mile road is Crawford County District.
Did you get pulled over there? Is that kind of? Okay. At that time, did you have possession of some methamphetamine?
Yes, Your Honor.
And did you know that that's what that was? Did you have any legal right to have any amount of it at that time? Is Coker people satisfied with the factual basis?
Yes, Your Honor.
Mr. Jack?
Yes, Your Honor, thank you.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
None, Your Honor.
And Ms. Koch, are the people satisfied that the court has complied with statute? Court will only take this plea.
Yes, Your Honor.
Yes, Your Honor.
Mr. Bartow, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of the added count 2 of use of methamphetamine. Court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with the probation officer for a pre-sentence interview to set that up. It's important that you cooperate with that process, and it's important that you stay in touch with your attorney so that you can prepare to go forward on the day of sentencing.
Yes, Your Honor. Thank you so much.
Thank you, Your Honor.
Yes.
Scope, are you ready on the Spencer?
Sierra Cook on behalf of the people.
Right, counsel.
Yes, that's a yes. John, on behalf of Mr. Spencer.
Mr. Spencer, you can come up to the podium here, please. We'll go on the record in People versus Cameron Spencer, file number 255404. This is the date and time set for sentencing. Record should reflect full counsel are present along with Spencer here in the courtroom. Ms. Cook, I don't see anybody in the Zoom waiting room. Were you anticipating any victims of your advice?
No, we have 2 present that would like to speak today in person.
Before we get started, Mr. Spencer, have you had an adequate opportunity to go through the pre-sentence report and talk to your attorney about that?
Sure, Honor.
And counsel, are there any additions, deletions, or corrections to that report?
Other than objections to certain calculations, no.
Okay. And I know Ms. Cook has some challenges to scoring. Do you have any challenges to scoring?
The only challenge that I have on my end would be for offense variable number 17, that should be scored at 0. So there was no vehicle involved, and Ms. Cope and her sentencing memorandum has stipulated essentially to that.
I would concede that that is correct. That should not have been scored.
And that's as to both charges?
Yes.
Okay, so the court will amend the report to score OB 17 at 0 points. What happens here? We'll adjust for final scoring. I'm not going to put that on the record yet. So no other challenges by the defense in this court.
No, Your Honor.
Okay. So Ms. Coke, before we get to your guidelines challenges, do you have any additions, deletions, or corrections?
No.
And your first challenge, and they kind of go hand in hand, are to OB1 and OB2. I did review your memorandum. I had a chance to do that in the case law that you cited. Is there any oral argument you want to present today?
No, I cited everything I did.
Okay.
Thank you.
Any argument in opposition?
Just briefly, Your Honor, my client has admitted to being the cause of the fire. That is given. What is not given is the origin of the fire. There was some statements made that he didn't have a lighter. There were statements made that he did have a lighter. There were statements made to a detective that the fire started by virtue of dryer lint being stuffed into a lint exhaust pipe, which was also seized as evidence. but nothing was returned of that. There was also mention of a burning stove as a possible origin of fire. And lastly, and most importantly, as far as an incendiary device goes, because that's the basis for these two variables. I believe MSP had a trooper come out with a canine to do a sniff for ignitable substances, and that resulted with 0 results, Your Honor. So essentially, it's not been 100% confirmed that incendiary device was used as the cause of the fire. So as such, those variables should not be scored.
All right, thank you. Ms. Koch, any responses to that?
Your Honor, they couldn't find what happened because the house was a total loss. This is different than the case I cited because it's significantly worse in terms of the damage that was done to the home. But he actually said what he did. He said he found a cloth and he lit it on fire. That's in the facts that were, and I used the facts specifically from the PSI for that reason. I used the wording there. And I think that's sufficient. I mean, the case I cited specifically is to OV2, which I think is even a stronger argument. But even with OV1, he said he started the fire. He did it on purpose. And he explained how he did it. So I think that has to be scored in an arson case. He didn't start this on accident. So I'd ask the court to score both of those. Thank you.
All right, again, I read through the PSI very carefully, as well as case law cited by Ms. Koch. The court has to find in scoring any variable, the court has to find that there is evidence by a preponderance standard to support scoring, and more likely than not, or still 1%, so forth. Can rely on testimony such as that given during trial or preliminary examination, or otherwise the court can rely on statements made to police reports, information from the PSI, victim impact statements, and so forth, making those factual findings. In this case, the court notes, number one, from a legal standpoint, I think there's mixed questions of law and fact. This variable is, or what is considered an incendiary device for purposes of OB1. It's defined by the statute, and I find that the Sindone case, even though it's unpublished, certainly persuasive in terms of what they qualify as an incendiary device as defined by statute. In that case, the court found that the fact that the defendant used a lighter or some other device to light a candle and then use that candle to other objects, the court found that as a legal matter qualified as an incendiary device is contemplated by the statute. In this case, the court is relying on the defendant's statements to police that he found the cloth duck on the stairs, put it near the wood stove, that he then later on admitted that in a different area of the home that he used a lighter and lit that cloth duck on fire and then put it inside the garage door, and then everything exploded and caught fire. The court finds that although there may be some factual questions here and some conflicting statements, and under a preponderance standard, which is more likely than not, the court finds that the defendant would be unlikely to make those kind of admissions, which would be so damaging to his own interests unless those were true. So the court finds that by a preponderance standard, the defendant did engage in the use of an incendiary device as defined by the statute and explained in the Sedone case. So the court finds that it does qualify under OB1. The court finds there's more than sufficient factual basis to support a finding that more than one victim was subjected to or exposed to that device, burning the home. There were a number of individuals present in the home, some of them asleep at the time. The court finds that there is adequate support for scoring OB1 at 20 points, and then again, because of its findings that the defendant's use of a lighter to light that object on fire and then use that to then ignite the rest of the premises finds that OB2 should also be scored at 15 points. The next challenge, Ms. Koch, is OB10. Is there anything that you wanted to state for the record to support that?
Nothing in addition to my brief, Your Honor.
I have no objection to scoring over 10. It's acceptable that there were victims who were asleep.
Okay, so the court will order that OB10 be scored at 5 points. And then finally, OB19.
Your Honor, OB19 is fairly easy to score under the case law. I think his statements, and actually kind of, defense counsel argued some of it today, but he made a lot of statements. He tried to cover up his tracks. He tried to say he was somewhere else. He tried to get his mother to cover up his tracks so that he could not be caught by law enforcement. I think he clearly, and I cited several cases that show that behavior meets the threshold, and I'd ask the court to score it. Thank you.
Your Honor, my client has assumed responsibility. Essentially, I'm only speaking with the detectives. In the report, there is a mention by one of the detectives when speaking with him and getting his ultimately his confession that my client was being otherwise straightforward. It's in the report, page 18, I believe. It says he is being straightforward on some things right now, which leads me to believe that he wasn't trying to mislead them. He wasn't trying to hinder any investigation. At the end of the day, that's to starting the fire. There was no attempt to hinder that investigation. And even the detective admitted that. He said being straightforward. I'd ask it to be scored at 0.
OB19 could be scored where there's interference with the administration of justice. Under the statute and the case law interpreting OB19, the court can consider conduct that occurs after the sentencing offense was completed. The court has to find that there is more than a mere denial of guilt. For example, the court would have to find that the defendant engaged in conduct such as actively redirecting the investigation by making false statements to law enforcement, concealing evidence deliberately from law enforcement so that they can't find it through the course of their investigation, preventing witnesses from testifying or giving evidence, or otherwise attempting to evade arrest. And all of those things go beyond just denying guilt, which the defendant has the right to do. So the court looks at the circumstances in this case, again, as indicated in the pre-sentence report. There's information in the pre-sentence report that the defendant, following the commission of the offense, but prior to his discovery by law enforcement, had engaged in erasing the different locations from his phone or other tracking device to show where he had gone that night, that he gave his mother instructions that she was to lie to anyone who came to ask about where he was that night, and made some statements, I think, implicating other individuals in this crime that was questioned by law enforcement. All of those things, in my view, go beyond a mere denial of guilt or refusal to talk or just cooperate with the police. All of those things were clearly designed by the defendant to evade detection by the police, to send the police in a different direction, and otherwise redirect the investigation. So the court finds, based on those facts, there's a preponderance standard. There's sufficient facts to score OB19 at 10 points. So when we subtract OB17 and then add the additional points in as the arson charge, the court comes to a total OB value of 85, which raises the OB level from 6%, results in guideline range as to the arson charge at 57.95. So do you agree with that calculation?
I do.
That's counsel objection to that calculation.
No objection.
Ms. Koch, are there any other scoring issues that we need to address?
Yeah, does it, and I did my objection primarily to, just so we have a clear record, as to the arson to home invasion second degree. Did they apply the same analysis for those? And does the scoring need to be changed?
In my view, those apply to the arson charge. So I don't believe those charges.
Oh. Okay, thank you, Your Honor.
Any issue with that?
No, I would ask.
Ms. Boak, do you have any other challenges?
No, Your Honor.
Mr. Spencer, can you be seated next to your attorney there? Ms. Boak, any victims that wish to address the court here today?
Yes, we have two.
I would like to state for the record that I did receive a victim impact statement from Mr. Lounsbury. I did read that prior to the hearing today. I also received a victim impact statement from Elizabeth Hoffman, and I did read that prior to the hearing. Where, and Adam, are you Skylar Ann?
Yeah.
You just state your full name for the record.
Skylar and Wolski.
What is it that you would like to say?
I don't really know what to say. Just, they really screwed up our life, kind of, because Gramps had like everything there, and Eddie, he really screwed up Eddie. He's changed so much since the fire, and we wouldn't be here if it wasn't for my friend Brooklyn. Just really hurts a lot because I cared about Cameron a lot, and yeah, we didn't really, have leave off good on good terms or whatever, but he shouldn't have done that. I don't really know what else to say. I just wanted to know that it really did hurt us, because now we're still waiting for our home to come, and we're living in a trailer, so a camper, and it's really hard. So just wanted to thank him for everything that he's taken away from us. Thank you.
Sir, can you tell me your name, please?
Don Lounsbury.
Okay, thank you. What would you like to say today?
Well, I don't know really. He burned my house to the ground. I lived there for 45 years. I lost everything. My wife passed away about 6 years ago, and she loved that house. I had all her pictures and all her things. 3 months after my wife died, my daughter died. I lost all her stuff that she gave me. It's just, I'm not happy. And I did nothing wrong in my house. And I can't understand why anybody would come in and burn somebody's house down when they're in there sleeping. And I just barely got out of there with my life. So I want him to get as much time as he can get. Because I don't want the fear of him coming around or anybody else, because I've had an awful lot of dreams. Every night I have trouble going to sleep over. And I don't even know this guy. It's the first time I ever laid eyes on him. Hope I never see him again. That's about all I got.
Thank you. Anyone else, Ms. Coe?
No, Your Honor.
Anything you would like to say on behalf of the people for Alex?
One of the things the court probably noticed is that there's no request for restitution.
Hold on. Sir, we're in the middle of a court proceeding here. What is it you need?
I was just telling that we're the grandparents. I didn't know if we could speak or not.
Ms. Koch has not indicated that. But...
I'm sorry to interrupt, Your Honor.
All right, okay, thank you. Ms. Koch.
Your Honor, we didn't ask for a restitution request, and I actually expected us to be requesting, $100,000 or $200,000. Everything so far has been covered by insurance, and some insurance companies are very good about getting us information. This insurance company has not responded to our request. They're still working on closing out the personal items that were lost, because as you heard from the victim who owned the home, he had 45 years worth of stuff there. I can't even imagine the number of things that he can't remember he had there. Everything from his family was in this home. So they haven't even got to that point. I think they've been living without water in a camper. Their life is destroyed because what Cameron felt emotional and wanted to do this on a bad day. When I read his character letters, I thought, am I even reading about the same kid? Is this even the same person? Because how does a person go from the person in the character letters to somebody who has destroyed this entire family's life? And, the emotional toll that this has taken on them. My victim advocate has been working with them repeatedly, trying to figure out a way. They're going to get they had to pay off their mortgage and then try to get a house, what was left on their mortgage. And it's a nightmare for them. They're not going to have the same quality home as they had before because there's no way for them to do it. They're not going to have a basement like they used to have. They're going to have a single wide trailer put on their property because that's the best way for their family to handle it. And frankly, I don't know how Mr. Spencer would help anyway. He's going to be in prison. I don't think the recommendation in this case by MDOC even starts to touch on the lifelong impact that this arson had on this family. I would ask for a sentence in the higher end of the guidelines. And I understand that Mr. Spencer's young. I understand that he has no criminal history at all. I don't even know how this ever crossed his mind to do it. It's horrible. And nothing I say today is going to change what happened to this family. And nothing this court does is going to undo the impact. But I think punishment should be the prime focus here. Thank you.
All right. Council here, your client can come back up. Podium. Anything you would like to say on behalf of your client?
Briefly, Your Honor, and I'd like to start with the first sentence of our sentencing memorandum that was submitted. It is well settled that a proper criminal sentence should be tailored to the circumstances of a particular case and to the particular characteristics of the defendant, ensuring objectives of sentencing are accomplished. Mr. Spencer is very young. He has his entire life ahead of him. He is extremely remorseful. He's embarrassed that this decision led him here. He was a captain of the football team in high school. He graduated with great grades. He was employed at the time. He had a desire to go into the armed services. And then he made this fateful decision. It was a momentary lapse and otherwise sound judgment. He has zero criminal history. He doesn't even know what it's like to break the law outside of the instant offense. Granted, this is a major offense, and thank God nobody was hurt or killed. But he is otherwise has a clean record, and this is something that is never going to happen again. He's never going to put himself in a situation again, or even have these thoughts of doing something similar. He has a low level of recidivism given his lack of criminal history. Again, this is a momentary lapse in judgment that unfortunately destroyed the lives of the victims here by virtue of losing their property. And he's extremely remorseful. And I would ask that, Your Honor, that you would impose a incarceration term of 2 to 4 years to allow him to get back on track and show this court that this is otherwise a hiccup in his timeline of life. He's going to go on to great and better things after he's done serving his time here, which may also include the armed services. I'm not sure. All I know is that he has expressed to me his remorse, apologies, and he wishes the best for the family. Nothing else, Your Honor.
Thank you, Mr. Spencer. Anything you wanted to say?
Yes, Your Honor, I'd just like to solidify what my attorney has said. Your Honor, I am extremely embarrassed to have to ever appear in front of you. I never plan, of course, nobody plans for much, but I never plan to ever commit any crimes or to be in front of you ever again. I feel horrible for the victims of the charges brought against me. I love and respect the victims. I think at this point, there's no doubt that I am the one that started the fire. And it was a mere mistake that I have made because of a long-term relationship of which I just loved somebody so dearly that I couldn't stand to lose them. And I never intended to harm them, but that is beyond my control at this point. I'm very glad that they're safe, no matter what they feel of me. Lastly, I'd just like to say that I miss my family a lot. I've learned a lot and met a lot of strange and hurt people in this county. That's all I have, Your Honor.
Okay. As I said, I read all the documents that were submitted to me prior to the hearing today, including the PSI, the sentencing memorandums, and the victim impact statements. I also read through all the information in the PSI, including the description of your actions throughout the course of this incident, as well as just general background about you and your circumstances. And of course, I listened very carefully to what victims who addressed the court here had to say today. And I say this frequently at sentencing hearings when victims give statements, and I appreciate you getting up here and talking about it. I think, outside of a death, of a murder, an arson where your home is completely destroyed has to be the next worst thing that could happen to somebody. And I'm sure it's difficult to talk about, and I'm sure the statements that you gave today don't scratch the surface in terms of the effect it's had on your lives and the lives of the other people involved. And Spencer, your actions in this case may have been a momentary lapse, and you are a young man. You're 19 years old, and people do things without fully appreciating the full consequences of their actions when you're that age. Your mindset is a little bit different. You're looking a little more short term, and I can accept that. But even in light of that, there are some mistakes that carry with them greater consequences than others, and simply can't be excused just by youthful immaturity. And this is one of those, because I think you are very lucky that no one was killed in the course of this, or seriously hurt, or you'd be facing much more serious charges than even the ones that you're facing now. And this is certainly, you set up a set of circumstances here where someone in that home certainly could have been killed or seriously injured during that fire.
I agree, Your Honor, and I just,
It's my turn now, okay?
I apologize.
So that's number one. You created a circumstance, put some circumstances in motion where people could have been killed or seriously injured, and that deserves serious consideration by the court, because to me, that's more than just the youthful discretion. That's a complete disregard for the lethal potential of your actions. And that's to say nothing of the actual loss that was incurred, which I said, I think next to someone dying, this has got to be the second worst thing that happens, because although you're not losing someone's life, you're losing all those memories of people who are gone, memories of people who are still here that you can never get back. Those things are erased permanently. And I think people feel the type of grief and loss from the loss of those kind of things almost as strongly as they feel grief and loss from a loss of an actual individual. And so this is a case where I think in particular, the court has to take into consideration the effect on the victims of your actions. And it's clear to me after reading them and hearing from them here today that effect has been significant. Taking all of that into account, the court finds that punishment and deterrence are two of the most important components of the sentence that needs to be accomplished in this case. I think based on your actions, based on the danger that you created, based on the immediate and long-lasting and really forever effects on the victims in this case, the court needs to impose the most serious punishment that it can impose. So therefore, the court finds that as to the arson charge, that you should serve a sentence in the Michigan Department of Corrections of 95 months to 20 years. You have credit for 228 days served. And that charge you will be required to pay restitution in an amount to be determined. You will be required to pay a crime victim's assessment of $130, court costs of $325, a DNA testing fee of $60, and a $68 state cost. As to the home invasion charge, the court is going to order 71 months to 15 years. Again, you have credit for 228 days served, $68 state cost as to that charge. On the malicious destruction of property charge, the court orders that you serve 1 year in the Crawford County Jail with credit for 228 days served. Restitution to be in an amount to be determined as to that charge, $50 state cost. All of those sentences can be served concurrent to each other. You do have the ability to seek an appeal of this sentence, and counsel, there should be Mr. Spencer's appellate rights on the table there. If you can have him initial where indicated to acknowledge it.
You need to sign every copy, or just the judge's copy?
Just the top copy, and then I get the top copy, he gets the rest of them. Thank you. Mr. Spencer, you are admitted to custody of the state at this time.
Your Honor, may I hug my grandparents?
No, we're gonna have to go right with the officer.
I understand.
People versus Michelle Danko, case number 255398.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of Lieutenant Michelle Danko. So you're gonna put that podium in.
Right up here, ma'am. This is the date and time set for sentencing this matter. The record should reflect Ms. Danko's presence in the courtroom today. Ms. Danko, did you have an adequate opportunity to go through the pre-sentence report? And talk to Mr. Thompson about that? Thompson, are there any additions?
No, thank you, Your Honor.
Are there any challenges to the scoring?
No, Your Honor.
Spoke, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I hate this case. I don't even know how Ms. Dinko went down this road. This reminds me of one of those documentaries you watch on TV and you just don't get it. Like it just keeps going. Like everything that she did in this case was a bad decision. And we've dealt with the co-defendant on this case. He definitely was the leader of the case. But how she would believe everything he said to the point that she was involved in stalking this other woman who she didn't know, had never met, and believed everything this man told her it's just ridiculous. But what's scary is that what could have very well happened in that other case is the defendant on that case is very, I can't think of a word besides unhinged, and could very well have, because of the results of Ms. Danko, ended up harming Ms. Gray. I don't know if Ms. Gray is present today to talk, but she was so affected by what happened to these people. She spoke several times in front of this court. We've heard her several times talk about the effects that her ex-husband and behavior had on her. But Ms. Danko was to buy somebody a stalking device to help install the stalking device to help track somebody you don't even know. It's just crazy. I think the recommendation is appropriate. I definitely think some jail is appropriate. I gave her a very good offer. I understand she was not the leader in this, and in lots of ways she was manipulated by that same gentleman. But I would ask the court to follow the recommendation. Thank you.
Thompson?
Unfortunately, Your Honor, I think we do know what happened. I think Ms. Danko got caught up in a relationship with a gentleman who's charming, manipulative, who's lying, and he got her to do things that she regrets. You know, she's now on the other side of this. Kind of like when I read Ms. Gray's victim impact statement, and I feel a lot of sympathy for Ms. Gray. She's definitely a victim here. She was definitely victimized. I don't discount that one bit. I think what she went through from Mr. Klum was horrible. I think Ms. Danko was unfortunately caught up in that same orbit for a brief amount of time. She has gotten herself out though. She's gotten legally divorced. She's cut off contact. She's not with that person. She's not in that combination. She's not in the middle of that situation that produced this very bad result. Mr. Klum was the leader here. He manipulated Michelle, and you know, Ms. Gray's statement talks about his character and his ability to do that. Ms. Danko feels very bad. She feels very bad, and she's taken steps to address this. She's divorced this man just now. She's getting herself out of that situation. And really, this is one of those cases where that's the whole ballgame here. In terms of when we talk to clients and we look at defendants in the situations they find themselves in, and how they can get themselves out of it. Sometimes it's a matter of doing what's very difficult and saying goodbye to a romantic relationship. I mean, she was in love. She was very much in love, and she has had to overcome that and had to do the right thing, and she has. And I just asked the court to take all that into account.
Thank you, Ms. Danko. Anything you wanted to say?
No, he had me by the GPS, he said for his son, to track his son, so I wasn't aware at first of any of this. By the time I was aware, I didn't even know he was literally stalking her. I thought he was just, seeing where she was.
Okay, well, I read through the report here. Gives me more information about your involvement in this. I'm aware of this circumstance. Generally, I addressed Mr. Bloom's case. So I was kind of aware of your involvement through that case first. This gave me more information, of course, about you generally, your background. Here. Looking at this situation as a whole, I can understand where Ms. Cope's coming from in terms of what she thinks your involvement is. I think it's equally possible, based on what I know of Mr. Bloom, that whether or not you should have believed him or should have accepted the things he was saying, see where that could happen in the course of this relationship based on the way that he did things with Ms. Gray. And I don't have any reason to believe that he treated you much, if any, different than he did her, or that his behavior was any different. So the degree of your culpability in terms of your actual knowledge and voluntary victimizing participation in this, I think is a little bit uncertain. And for those reasons, I think I'm going to give you an opportunity to avoid jail through probation. I'm going to hold some jail time in advance over your head, place you on a lengthy period of probation. If you do well on probation, you can be discharged early from that, so you may not have to serve that entire term of probation. But I think a long term of supervision, make sure that you're not engaging in wrongful conduct. I think is appropriate, and if you don't, then you'll have to serve it. I think that addresses both sides of this equation. So the court is going to place you on probation for a period of 5 years. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. The court is going to, again, order that you serve 60 days in the Crawford County Jail with credit for 1 day served. The court's going to hold that time. And you don't have trouble on probation, you won't have to serve that time. If you do violate your probation or have issues on probation, then I can impose any or all of that jail time immediately, without any hearings or anything. not pass go, go straight to jail, okay? So it's really important that you comply with your probation. Court is going to impose a crime victims assessment of $130, court costs of $325, fine of $500, attorney fees of $350, $60 state cost, and a $30 supervision fee while you're on probation. You do have the ability to seek an appeal of the sentence. Mr. Thompson's going to give you your appellate rights here that explain to you how to do that.
Sure. Stanko, you just acknowledge receipt of these by putting your initials here. It's not the same as filing an appeal. You can read the papers and file them within 14 days if you wanted to file. This is just here's to keep. Leave this here, Your Honor. Okay.
Yes.
All right.
She does.
So the fee from okay. Versus Travis Eisenhower, case number 245362.
And Vernon, on behalf of Mr. Eisenhower.
Sierra Coke on behalf of the people.
So we have a plea agreement here, Mr. Eisenhower.
Plea agreement is to possession of methamphetamine as a habitual fourth offender, dismiss the delivery charges.
And accept that sentence. That's what we talked about yesterday.
Possession of 10-year felony.
Yes,
Yes, I'm sorry, I had the statute number.
it's 333.74.
We don't have Sarah here right now, anyway, so
Okay.
she'll get it from you later, I'm sure.
Okay,
Okay. Mr. Eisenhower, have you heard what we stated regarding the plea agreement?
Yes, sir.
Is that what you discussed with Mr. Vernon?
Yes, sir.
Is that how you wanted to proceed today? Yes. Raise your right hand, please. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you. Mr. Eisenhower, are you currently on any probation or parole?
No, Your Honor.
You understand that by pleading guilty to this added count of possession of methamphetamine, that the maximum possible sentence you could receive would be up to 10 years in jail.
Your Honor, that's with the habitual fourth notice. I just want to make sure the record's clear.
I'm sorry about that.
It's with the habitual fourth offender
Oh,
notice.
with
Yes.
Okay. So that means that the maximum possible penalty is up to life. You understand?
Yes, Your Honor.
That in mind, what is your plea to that charge? Guilty. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court ordering witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want. You understand all those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal by leave. That means you have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead today?
No.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
This happened on November 24th of 24, is that correct?
Yes.
On that date, were you present here in Crawford County?
Yes.
And when you were here in Crawford County on that day, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that was?
Yes.
Did you have any legal right to have any amount of it at that time? Ms. Coker, are people satisfied with the factual basis?
Yes, Your Honor.
Marvin?
Yes.
Ms. Coker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
I did go over his guidelines with him. That may have been an inducement. I did advise him specifically that this court is not bound by my scoring of the guidelines, that it was not part of the plea agreement. And that if my scoring was different in the courts than the courts, that would not be grounds for him to withdraw his plea.
Okay, that's absolutely right. Do you have any questions about that, Mr. Eisen?
No, Your Honor.
So you understand that whatever you and Mr. Vernon have discussed is in terms of a possible sentence may or may not be actually correct as later determined.
Yes.
Ms. Coker, are the people satisfied that the court has complied with statute or support law?
Yes, Your Honor.
Yeah.
Mr. Eisenhower, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding guilty of the added count two. The court will accept your plea. We'll set this matter for a sentencing hearing. You'll be notified of the date.
No.
He had given me a piece of paper he wanted me to make a copy of. I would just ask that he be remain in the courtroom for 5 minutes, probably go make that copy. Thank you.
Thank you.
And with that, I would ask to step out.
Sure. People versus David Law, case number 212. Wait a second. Mr. Brown.
I did. I was gonna say, after we talk to the judge, if it's okay with it.
Yeah, that sounds great. Thank you.
Are you ready on Mr. Law's case?
I am now, yes, thank you, Your Honor.
Court will call People versus David Law, file number 255382. Mr. Law's present today.
Your Honor, Adam Brown, on behalf of Mr. Law, who's present standing at the podium, Your Honor, we've reached a resolution in this matter, if I may have.
Yes.
Sierra Coke on behalf of the people.
So, under the terms of this agreement, Mr. Law will be pleading guilty to count 2 and count 3 of domestic violence, second offense, and that the aggravated stalking charge would be dismissed.
The home invasion would be dismissed.
Oh, I'm sorry.
Yes, Your Honor.
Yeah, so he's pleaded into 2 and added 3, stalking and domestic violence with the home invasion being dismissed.
Ms. Hope, that's correct.
Yes.
Mr. Law, is that the agreement that you've discussed with Mr. Vernon?
Yes, sir.
And do you need any more time to talk to him about that, or are you ready to proceed with that today?
I'm ready to proceed.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Lower your hand. Were you on probation at the time of this, Mr. Law?
Yes, sir.
And you understand that there could be additional penalties for violating your probation by you entering into this plea today?
Yes, Your Honor.
And you understand that the maximum possible penalty you could face for count 2, which is aggravated stalking, is up to 5 years and or a $10,000 fine, including probation of up to 5 years.
Yes, Your Honor.
And you understand that by pleading guilty to an added count 3 of domestic violence, second offense, that the maximum possible penalty you could face would be up to 1 year in jail on that charge.
Yes, Your Honor.
All of those. Do we have, Mr. Vernon, are you aware of any potential consecutive sentencing sanctions in this case?
I'm not.
I am not.
So with all of those penalties in mind, Mr. Law, what is your plea to those 2 charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty, including the right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for leave to do that. That means you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of that appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea? Yes. Are you pleading guilty because you are guilty? Yes. Yeah. So this occurred on or about January 4th of 2025. Is that the correct time frame?
I do believe so, Your Honor.
Okay. And Mr. Brennan, ask this at aware of those.
I can do this. Yeah.
Might be easier in this case.
On the dates in question that the court provided, you were aware that there was a prior order prohibiting you from having contact with the victims in this case?
Yes,
And despite that, did you have contact with the victims in this case?
I did.
And how did you do that?
I went back to my home for the holidays.
And did that cause Amanda Ray Hall to feel threatened?
Later on, we got into a.
Yes or no?
Yes.
Thank you. Your Honor, I think that satisfies the aggravated stalking.
Oh,
I would agree.
okay.
And then with regards to the domestic violence, when you had contact with Ms. Hall, did you do something that made her feel threatened while you were present in the home?
Yes.
And what was that?
I had a knife and I was shelving.
Your Honor, I think that satisfies, and all that took place here in Crawford County.
Yes.
I think that satisfies the domestic violence.
I would agree, Your Honor.
Okay. Mr. Law, had you previously been convicted of domestic violence prior to this?
Yes, Your Honor.
Ms. Polk, are the people aware of any threats, promises, or inducements other than what's placed on record?
No, Your Honor.
Likewise, in this case, I did go over his sentencing guidelines with him. I explained to him that my evaluation of the guidelines may be different from the courts, but the courts would be the one that would be binding, that mine are not binding on the court, that they're not part of this plea agreement. And if the court determined that they were different than when I scored them, that it would not be grounds for him to withdraw his plea.
Mr. Law, do you have any other questions about what Mr. Burns just indicated?
No, Your Honor.
You understand that regardless of what the two of you have discussed in terms of a potential sentence, that that may or may not be actually what the guideline is?
Yes, Your Honor.
Ms. Polk, are the people satisfied that the court has complied with statute and court rule?
Yes, Your Honor.
Yes.
The court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are charged. The court will accept your guilty plea as a whole. We'll set this matter for a sentencing hearing. You're going to meet with one of the probation officers here today to set up a pre-sentence report. It's just important that you stay in touch with Mr. Vernon prior to the sentencing hearing so that you're prepared to go forward.
I should go to the phone number.
Yes, I'll give that to you.
Is,
I don't know that I need that, but definitely make sure
Okay.
that Mr.
Okay.
is correct.
thank you, Your Honor.
All right, that concludes our morning docket.
I think we added Brinker to talk about, I think Sarah added it to talk about the bond
I
issue.
don't think Sarah added it.
Okay.
There was some discussion of that. And
Can we discuss that with you very briefly? Doesn't have to be on the record. Okay.
I think we have a proposed stipulated order.
yes, I do want to put it on or have this be on record.
Okay.
I'm not going to call the case. stipulation.
Your Honor, there is, Mr. Brinker has a bench warrant out, and, he's in the hospital. I've received multiple documentations and met with his mom. I've also seen photos of him. He had a surgery. He was in the hospital in the emergency room the day of this incident, and then he has since been transported to Traverse City. I think he might have got out, but went back in. He's under some pretty severe medical issues. I've heard all Mr. Ricker's excuses for a good solid decade. So I required a lot of documentation before I'd sign that stipulation. But the stipulation includes an addition that when the bond was done in this case, the box was checked. It says do not use, but it doesn't check any of the additional boxes. So the stipulation is to withdraw the bench warrant, but to include the no use of alcohol, marijuana, or illegal substances, and that once he's released from the hospital, he'll wear an alcohol monitor. I'm just telling the court because the court's been through this with Mr. Brinker. I've been through it, and so I didn't want to just present a stipulated order without explaining what happened and why.
We have that right now.
We do.
Yeah.
We do. It's been signed by Mr. Thompson. He's been off and on standby counsel or counsel, but
Yes.
Mr. Brinker's aware of all this.
So my technical appointment is standby counsel, Your Honor. Or whatever that's worth.
Do you want me to just hang on? I don't know.
Process it and hand it to Sarah. I think is probably the best way to do it.
Sarah's not in today.
I know, but I mean, he's in the hospital. No one's gonna pick him up on the warrant. There's not much I can do with it until Sarah
Do
processes
you
it.
want this, Mr. Thompson?
A copy of it and
Yeah, I'll take it to the clerk's office.
make a copy.
Arrange
And
copies. Thank you.
All right, the court will be in recess until 1:30.
We're a short docket. It was a rough one.
All right.
Doesn't the insurance company have to put them in something better than a trailer?
It doesn't even have running water.
They need to get a lawyer then, 'cause most insurance policies, they have to stay somewhere nice for them,
They
like
don't,
habitable.
I don't think they have.
They have terrible coverage.
No, I think they have decent coverage. Tasha said, I don't think they could find a place. I don't know. I don't,
That's good.
I don't think so either.
Insurance company has to make that right.
I will. Let Tasha know. Tasha's looking because her house is out. Oh, I will.
Yeah. Hi. Yeah, let's go see if there's someone in the clerk's office who can make us some copies. Yeah.
Yeah, find a way to get her off the hook and he's gonna fuck up. So. And he will.